I want to deal with the relationship between the European Court of Human Rights and the domestic courts, at least as far as it impacts upon the doctrine of precedent. The key case here is called Leeds City Council and Price and Kay and the London Borough of Lambeth, a case from 2006. And I want to refer to Lord Bingham in the House of Lords, who outlined the fundamental issue, I think, in a very clear way. The fundamental issue here is whether a court which would ordinarily be bound to follow the decision of another court higher in the domestic hierarchy of courts is, or should be, no longer bound to follow that decision if it appears to be inconsistent with a later ruling of the court in Strasbourg. Now, this is a novel problem, isn't it, that comes out of the relationship between the domestic courts and an international court, that international court being the European Court of Human Rights. And the issue is, since rights were domesticated under the Human Rights Act, what is the relationship between the jurisdiction of the international court, the European Court of Human Rights, and the domestic courts as far as the domestic hierarchy of courts is concerned? And the kicker is this, again, to just stress what Lord Bingham's pithy summation of this problem is. Here's the issue. Whether a court which would ordinarily be bound to follow the decision of another court higher in the domestic hierarchy is or should be no longer bound to follow that decision if it appears to be inconsistent with a later ruling of the Strasbourg court. So what's an example? How could this happen? Well, let's almost go back to what happened in Davis and Johnson. In other words, Lord Denning was trying to argue that the Court of Appeal should depart from its previous rulings. This problem now appears in a different way, given the new context, the new circumstances post the Human Rights Act, and given the relationship between the jurisdiction of the European Court of Human Rights and the common law. What if the Court of Appeal is deciding a case and there is a ruling of Strasbourg, of the Strasbourg Court, of the European Court of Human Rights, that suggests that they should develop the law in one way, and that is consistent with either an earlier ruling of the Court of Appeal or indeed an earlier ruling of the House of Lords? There's clearly a problem here. Which way should the Court of Appeal turn? Now, Lord Bingham has a very clear answer, and the clear answer is that we affirm the domestic hierarchy. This is what he says. Lord Bingham invokes the spectre of confusion that would haunt the common law if the settled arrangement for the creation of authority was disturbed. In other words, what Lord Bingham is saying here is, in the face of this complex relationship that has developed since the Human Rights Act between domestic courts and the European Court of Human Rights, we fall back on the conventional understanding of the doctrine. In other words, the Court of Appeal, in our example, would have to follow the earlier ruling of the Court of Appeal or indeed the ruling of the House of Lords. It could not use the inconsistency between the earlier ruling of the Court of Appeal or the ruling of the House of Lords with the Strasbourg decision to justify departing either from the earlier ruling of the Court of Appeal or indeed from the ruling of the House of Lords. The certainty of the common law, according to Lord Bingham, is achieved by adhering, even in the convention context, to our rules of precedent. If an authority is inconsistent with the Strasbourg ruling, then it is best dealt with as an appeal, and the House of Lords or the Supreme Court given the opportunity to produce a definitive statement of the law. Lord Bingham supports his position with a second argument. The Convention requires a constructive dialogue between national courts and the European Court of Human Rights. The Strasbourg Court has the authority to pronounce on the Convention and the correct interpretation of its principles. However, in its decisions on particular cases, the Strasbourg Court allows a margin of appreciation. It allows a national court, a domestic court, to develop and apply their own understanding of the law to the facts of the case. This means that the national court must decide precisely how the Convention applies and how the principles elaborated in Strasbourg should be applied in the special context of national legislation. If the national courts have to apply Convention jurisprudence or the rules of the European Court of Human Rights, then they must do so in the prevalent terms of the national legal system. Thus, as far as the UK is concerned, the ordinary rules of precedent should apply.